Today, I visit with Jonathan Wilson on his recent book, The Corporate Transparency Act Compliance Guide. Hello, everyone. This is Tom Fox back for another episode, and I'm absolutely thrilled to have back with me Jonathan Wilson. Jonathan is the author of The Corporate Transparency Act Compliance Guide. And we're going to visit with him about the book, the substance of the law, and take a little bit deeper dive than we did in our prior podcast. So, Jonathan, with that incredibly long-winded introduction, welcome back to the podcast.
Well, thanks so much, Tom. It's great to be here with you.
Could you tell us again your current practice area, Jonathan?
Sure. So I'm an attorney at the Atlanta-based law firm of Taylor English Duma, and my practice there is basically, middle market M&A and securities. We do a lot of private offerings and a lot of work with startups and growing businesses. But then I'm spending increasing amounts of time with a company that I founded called the FinCEN Report Company at FinCENReport.com. And it is an online filing service that relates to the reports that we're going to talk about under the Corporate Transparency Act.
Well, this is an author's podcast, so I have to start with, why did you write this book?
Sure. Well, when I first heard about the Corporate Transparency Act, which is going to require more than 30 million U.S. companies to file with the U.S. Treasury a document that contains very sensitive personal information of all the beneficial owners of the company, I could tell that it was going to be confusing for people. The Treasury was going to be asking business owners to file a document that they had never filed before. It was going to require them to collect personal data regarding their beneficial owners that they'd never collected before. It was going to require them to undertake this legal analysis to determine who are the beneficial owners, which was something they had never done before. So I could tell it was going to be confusing for business owners and for the lawyers that advise them. So in order to get to the bottom of it all, I did my own deep dive into the statute, into the regulations that FinCEN has published so far and those that FinCEN is planning to publish. And I pulled all of that together in one synthesis, one book that basically boils it down, tells you everything that you would need to know as a lawyer to advise your clients through the process of identifying beneficial owners and filing their first report.
How long did it take you to write your first draft?
I probably worked on it for several months. I tend to be a pretty fast writer. I actually wrote an earlier book in just a week, and I just kind of dive right into it and go hours at a time. So this one took several months, mostly because, as you know, the Corporate Transparency Act and its regulations don't latch very well onto each other. You sort of have to take the statute and then take the regulation bit by bit in order to make them line up and make sense out of them. But that's about how long it took.
So you told us what the law generally is going to require in an overview, but why was the CTA enacted?
Sure. Well, it's important to keep that in mind, because some of the things that this law is going to require are going to sound counterintuitive and strange to business owners. But if you remember the purpose of it, it makes a little bit more sense, even though it's still going to be a pain in the neck for everyone. And that is that the CTA was adopted by Congress in order to fight money laundering. Money laundering, of course, is the process by which bad actors take illicit funds and try to make them appear as if they were legally derived, and in order to pay tax on those funds and be able to use the money. The classic example that we talk about in the introduction to the book is Al Capone. Al Capone, of course, famous gangster, killed people, was running illegal alcohol and drugs into and out of the country, operating gambling rings, all kinds of illegal acts. And he was never convicted of any of those things. How the feds got him was because they were able to show that he was living with a very grand and expensive lifestyle, and yet declaring that he had no income. And the argument at trial was basically the man must be lying because he clearly has money and he has no income. Therefore, the income that he has must be illegally derived. And that was really the beginning of money laundering in America. And ever since then, the fight against organized crime has been the fight against money laundering. If you think about, the TV show Breaking Bad, right? And by the end of his career, he had these, piles of cash buried in the desert. Why was that? Because he couldn't launder the money. He had so much cash that he couldn't possibly come up with a superficial rationale as to where he might have gotten it from. And so it was effectively useless. Well, money laundering has been called the life's blood of organized crime. And in most of Western Europe, there are already systems in place to make public the ownership of private companies, because it's the use of anonymous companies that makes money laundering possible. And the CTA is the US Congress attempt to catch up with what Europe has already done by effectively eliminating the idea of anonymous corporations by requiring these beneficial ownership filings to be made with the US Treasury Department.
So the beneficial owners, could you tell us what a beneficial owner is, and then what is control under the CTA?
Sure. So in the report that every non-exempt company will have to file, the company will need to identify its beneficial owners. And an individual is a beneficial owner if that individual, directly or indirectly, either owns 25% or more of the reporting company or has substantial control over the reporting company. Now, each of those two prongs is separate, and each of them is fairly complex. There are a series of rules for calculating percentage ownership, and those rules vary based on whether the reporting company is taxed as a partnership or is taxed as a C corporation. Then there is the substantial control prong. And again, this is a fairly complex definition because the purpose of the act is to weed out money laundering and to catch situations where there may be some bad actor hiding in the wings, directing all the activities of everyone else while not actually owning anything. They have defined substantial control very broadly. And a person has substantial control if they are a senior officer of the company, if they have the power to appoint or remove a majority of the board of directors, if they have the power to appoint or remove any senior officer, or if they have the ability to exert influence over major decisions. That's where most people are going to get caught up in the definition of substantial control. So if you consider, for example, your basic LLC operating agreement, where we have a bunch of investors come together and one individual is treated as the manager and he runs the day-to-day operations of the business. But the operating agreement says for any of these major decisions, we're going to have a vote of all the investors. Well, that provision right there, giving investors the power to vote on major decisions, converts every one of those investors into a person with substantial control because they now have influence over major decisions. So to sum it all up, if you were trying to figure out all the beneficial owners of a company, you would first identify every individual who has beneficial ownership by means of the various ownership rules. Then you would go through a second time and identify everyone who fell into any one of those various categories: senior officer, power to appoint, and exerting influence over major decisions. And all of those individuals would also be beneficial owners. So collectively, both sets would be all the beneficial owners of the reporting company.
What is a reporting company and what entities are exempt?
Sure. So again, the idea that Congress had in this law was to capture as many entities as possible. And they defined a reporting company as a corporation, LLC, or other company that is formed by the filing of a document with the Secretary of State or registered to do business in a state by virtue of filing a document with the Secretary of State. So obviously corporations are covered. They're formed by the filing of a document. LLCs are covered. They're formed by the filing of a document. Limited partnerships are covered. They're formed by the filing of a document. General partnerships may or may not be covered. It depends on your state. In my home state of Georgia, we can create a general partnership without filing any document. In the state of Delaware, however, a general partnership does require the filing of a document. A lot of people have trusts, for example, to hold their life insurance policies. Most individual life insurance trusts do not involve a filing of a document with the Secretary of State, so those ILITs would not be reporting companies. But a Delaware statutory trust is formed by the filing of a document with the Delaware Secretary of State, so a Delaware DST would be a reporting company. So it's something that, for some of these edge cases, business owners will need to consult with their attorneys. Now, once you're a reporting company, the next question is your reporting company exempt? There are 23 different categories of exemption. I'm not going to try to list them all. In general, exempt entities are the ones that already are subject to some sort of regime or legal requirement that has them filing with some organ of the government information about who owns and controls the company. For example, banks. Banks are exempt. Credit unions, thrifts, savings and loans, they're all exempt. Insurance companies are exempt. The exemption that will most often be at play for most businesses is what FinCEN has called the large operating company exemption. And perversely, if you are a large operating company, you're exempt. If you are smaller than a large operating company, you are not exempt. So one of the criticisms of the law is that it tends to put the burden of compliance on the smallest companies and relieve the largest companies of the duty to comply. In order to be exempt under the large operating company exemption, the operating company must have 20 or more full-time employees, with the definition of full-time employee being used under the Affordable Care Act. It must have gross income of $5 million or more, as reflected on its last tax return, and it must have a place of business in the United States. So all greater than 20 employees, greater than 5 million on the last tax return, place of business in the United States. You meet all three of those, and then you are a large operating company and you are exempt. But one of the things to watch out for, again, are the edge cases. Let's imagine that you will have 21 employees, $5 million place of business. You're exempt. Business gets bad. You have a layoff and you let go 2 of your employees. So now you only have 19. You have just ceased to be exempt. And now from the time you execute that layoff and reduce your head count below 20, you have 30 calendar days in which to file your first report, since you're no longer exempt from the reporting requirement. So the exemptions are going to be very tricky, and it's something that business owners who have companies that are near the borderline will need to take into special account.
I haven't heard you mention a dollar amount yet. If you did, I missed it. Is there any dollar amounts around exemptions, either low end for corporate income or top end?
Well, there is no top end. For the large operating company exemption, we talked about the 3 prongs: 20 employees, $5 million in gross receipts reflected on the last tax return. That's really the only exemption that has anything to do with a dollar amount. Once an entity is exempt, you could have $1 billion in income and you're still exempt. Publicly traded companies, for example, are all exempt. So regardless of how much money they have, if they're a 34 Act filer, they're exempt from the reporting requirements.
It strikes me that having the public company exemption speaks to the desire of Congress as much as anything else in the law to try to fight money laundering, because whatever U.S. public companies may or may not do, they're typically not charged with money laundering because of other controls in place. Would that be a fair assessment?
That would be. And not only are public companies relatively unlikely to engage in money laundering because they are regulated and audited and so on. And the Sarbanes-Oxley Act, for example, imposes a requirement to have internal controls in a publicly traded company, but also because all the information about a public company is publicly available. You can go to the SEC website and find out who are the senior officers, who are the directors. You can look at the company's last 10K and find out who are the shareholders that own more than 10%. That information is available by the public company. So if there was a problem, the FBI, the DOJ, they know where to go when in the case of a public company. In the case of private companies, shell companies that don't have a permanent place of business, those are the ones that are more susceptible to money laundering because law enforcement doesn't know where to go to serve the search warrant or to conduct an inspection and so on.
Jonathan, when is initial reporting due?
Sure. And that's been something that folks have been watching very carefully. The law was passed, of course, back in 2020, at the tail end of that year. And Congress told the U.S. Treasury Department, acting through its Financial Crimes Enforcement Network, or FinCEN organization, to implement it by the end of 2022. They missed that deadline. So they have been trying to catch up with the timeline ever since. They adopted regulations in September of 22, and they will take effect on January 1, 2024, less than 100 days from now. So any company that exists before January 1, 2024 will have 1 year from that date in which to file a first report. Any entity formed on or after January 1, 2024 will have 30 days to file a first report. But we have to put a footnote on that last rule. Just 2 days ago, FinCEN announced a proposed rulemaking that would extend the filing deadline for companies formed on or after January 1 to be 90 days from the date of formation instead of 30 days. Now, that rule hasn't taken effect yet. It is open for comment until the end of October. But my money is on the fact that FinCEN is going to adopt the rule that it's announced, and it will be giving those newly formed companies 90 days in which to file. And again, all of that takes effect January 1, 2024.
How does the CTA, in your opinion, change compliance?
Well, it's going to have a dramatic change on compliance. In particular, before now, if you were a new company, you develop a business plan, you have some promoters, you then go out and raise money from investors. You're probably doing an exempt offering under Regulation D for the securities lawyers who are listening, and you make disclosures about your business plan, what you hope to do with the money. The investors promise you that they're accredited investors. They write you a check, they sign your subscription, the money comes in, you go out and spend the money and hopefully have a successful business. You may have obligations to report back to your investors as to how things are going, perhaps an obligation to give them quarterly financials or something like that. But you never expect as the company to continue to collect information from your investors. Information flows out, it never flows in. The CTA changes that. Now, because the company has the duty to report the PII of its beneficial owners, the company needs to impose on beneficial owners an obligation to report their PII back to the company so that the company can include it in the beneficial ownership report. That is just a complete paradigm change in the way we think of information flows between investors and the company. Now, how you address that is a separate concern. For my clients, I've been advising them to modify their shareholder agreements, modify their operating agreements to include the concept of CTA compliance so that beneficial owners are required to apprise the company's compliance officer of their PII for reporting purposes. One of the key elements of the CTA is that the reporting company has an obligation to file an amendment within 30 calendar days after any change in previously reported data concerning one of the beneficial owners. So Tom, you and I have an LLC. It files its first report. That first report includes for both you and me our full name, date of birth, home residential address, and then our driver's license or passport along with an image of that document. After we file the first time, you get a new home because this podcast has been so successful and you're so tremendously wealthy, and your home address changes. Okay? From the time your address changes, our little company has a duty to file an amendment with your new address in it within 30 calendar days. Well, our company can only do that if you are obligated to tell our company about your new address. So that is a major change in the world of compliance as it relates to privately traded companies.
I'm almost reluctant to ask this next question, which is, when should companies begin to prepare? And you may say, well, it was about a year ago. It was 6 months ago. Call me today after this podcast wraps. But what are you counseling your corporate clients on up and down the spectrum at this point, recognizing we are 3 months out from 2024?
Sure. Well, and I think you probably are right that the time to begin preparation was sometime before today. But if you haven't started yet, there's no time like the present. You should get started now. For companies that already exist, my suggestion is to go through your constituent documents, make sure that your cap table is up to date, and then engage with counsel who has some experience in dealing with the Corporate Transparency Act to help you go through the process of figuring out who are your beneficial owners, communicate to them that they're going to need to give you their PII, and then find a reporting tool for you to collect this information and be able to file it with FinCEN when the time comes. In addition, reporting companies should consider adopting a compliance policy and appointing a compliance officer. The CTA does have criminal penalties associated with a willful failure to file. Those criminal penalties are visited on the heads of the senior officers of the company. Senior officers include the person who acts as the president, the person who acts as the general counsel, the person who acts as the CFO. And importantly, the definition is regardless of formal title. So if you actually and in fact act as the president, then for CTA purposes, you are, which means that you bear personal criminal liability if you fail to report. And that personal liability can include felony conviction and imprisonment of up to 2 years. And in the case of an inadvertent failure that it makes you filing late, there is a per day fine of $500 per day. So there are going to be some teeth in this law. Some other things to think about, in addition to getting your own house in order, pulling your constituent documents together, figuring out your cap table, finding counsel who can advise you about how and when you're going to need to file, you need to think about how you're going to integrate that compliance with other aspects of the business. Do you have a senior credit agreement where the bank is the lender? Because banks very soon are going to begin to compare the information you provide on your Know Your Customer form with the information you provide to FinCEN in your CTA filing. Now, that's one of the regulations that FinCEN hasn't finalized yet, but they are proposing to finalize it next year. And I expect we're going to see a lot of developments in that regard. I've already seen, for example, banks adding to their standard new account documents that the customer, the company, is consenting in advance to give the bank access to the company's CTA report when and if it gets filed. So you should be watching out for that. We should also think about how CTA compliance is going to dovetail with M&A due diligence. Let's say, Tom, you and I form our company, and once again, it's wildly successful. And Tom, I just lost my screen. Am I on?
Yes.
Let's say, Tom, you and I are so successful, we are going to go out and we're going to do some acquisitions. And we're going to buy another little publicly traded company. Just as we would in any other due diligence exercise, we're going to serve our due diligence checklist onto the target. We're going to ask for their material contracts and so on and so forth. We're going to ask them to represent that the company is in compliance with all applicable laws, one of which, of course, is the CTA. Well, we're going to have to figure out, as part of the due diligence process, did our target company correctly file its initial report? If so, did it correctly and timely file every amendment that was required? Well, how are we going to know that unless we know the birth date and home residence of all the beneficial owners and can track changes in that data over time? That would be the only way that we could ever validate whether a target company's CTA filings were accurate or not. If we worry that they perhaps were not accurate, what sort of liability could there be for us as the acquiring company? And is there some sort of reserve or holdback that we would want to account for as part of our M&A negotiations? So the CTA is going to have very far-reaching effects, and I think we're really just scratching the surface right now as to how it's going to change the world of small and medium-sized company business transactions.
Jonathan, we've taken in this podcast a broad overview of the text of the book itself, but you've got several very useful appendices. Being a good lawyer, you, of course, attach the statute. So I'm going to pass on that one. But you've got 3 appendices which give model forms of either suggested amendments for an LLC or a C Corp, or a potential language for a compliance component. Could you say a few words about those?
Sure. Well, you described them very well. What I wanted to do for readers was, after saying what the law is, what does it do, and how do we comply with it, I wanted to provide some samples for the sort of things that I think counsel should be discussing with clients in this space. So as I described, there's a model clause that you could add to your operating agreement to obligate all of the beneficial owners, all the investors, to provide their PII to the company compliance officer. Basically the same clause modified to fit into a corporate shareholders agreement to do the exact same thing. And then a model CTA compliance policy. Importantly, remember I said that the criminal liability for a failure to file rests on the head of the senior officers. There's nothing we can do or say in our documents that makes that liability go away. But I suspect that there will be some mitigation of that liability if a company has a compliance officer and a subsequent failure to file arises where the senior officers thought everything was being properly attended, but in fact the compliance officer fell down on the job. I think this would also tend to support a defense for the board of directors. If the board of directors appoint a compliance officer, empower that compliance officer by adopting a compliance policy, modify constituent documents to incorporate the compliance policy, obligating the investors to provide their PII, and then there's a failure, I think we've pretty carefully placed the blame on the shoulders of the compliance officer, which would be a potential defense or a defense and mitigation that the investors and the board of directors would have. So those appendices in the book are intended to help counsel have those conversations with clients as part of this process.
Have you made a determination or even a suggestion on who in the corporation should be responsible for this? We've used the term compliance officer. That can be several different positions. So I was wondering if you think it should lie in if there's a compliance function, should it lie with the general counsel? Should it lie with a corporate secretary, if any, in an organization, or something else?
I don't know that I have an opinion as to who should be the compliance officer. Since we're talking about, small companies with fewer than 20 full-time employees, less than 5 million on last year's tax return, larger companies that have in-house general counsels are likely to be exempt. It's the smaller companies that are going to bear the brunt of the reporting, and they tend not to have that big of an in-house, legal or administrative function. As I mentioned, the penalties, the criminal liability for a failure to file always rest on the senior officers, regardless of whether someone has the title and duties of a compliance officer. So no, I don't really have an opinion as to who would be the best compliance officer. I think that would be a facts and circumstances determination. What is important, I think, is having a compliance officer and a compliance policy, because that would tend to mitigate the liability of the directors if there is a failure. Having a compliance officer and a compliance policy shows that the board of directors gave the issue due attention, that they took action to do their best to see that the law was complied with. And that's as farthest as I've been able to take it so far.
Well, Jonathan, where can listeners buy your book?
Sure. Well, you can find the book on Amazon, the Corporate Transparency Compliance Guide. You can also find it on LexisNexis. LexisNexis, through their Matthew Bender imprint, is the publisher of the book. And I know every time I go out to a website now, I'm getting covered up with web ads for my own book. It must be the way the advertising algorithms work or something. But you can definitely find it on LexisNexis and on Amazon.
Jonathan, if someone wanted to contact you individually, either in for your legal practice or for your tool or solution that will help facilitate compliance with this law, what would be the best ways for them to do so?
Sure. Well, you can find information about the solution at FinCENReport.com. That's FINCEN report.com. And then my email is jwilson, just the letter J and the last name Wilson, at FinCENReport.com. I'm getting a lot of emails these days, but I do respond to every one of them. So I would love to hear from anyone who wants to hear more.
Well, Jonathan, once again, thank you for coming back. Congratulations on the book. I understand what a big deal that is. And I hope we can continue our educational series for our fellow compliance lawyers and others going forward.
Absolutely. And thank you so much for having me, Tom. I really appreciate the opportunity to speak with your audience.
This is Tom Fox again. I hope you've enjoyed this edition of the Sunday Book Review Authors Podcast. I hope you'll subscribe, rate, and review wherever great podcasts are listened to. The SBR Authors Podcast is a special production of the Compliance Podcast Network.